Good evening, everyone, and welcome to the lecture series of CLAT preparation of 2023. In this particular lecture series, we are talking about one of the most essential topics of CLAT preparation, that is legal reasoning. In the legal reasoning, we have in our previous lectures we have discussed that the subjects that is expected by the students to study is basically 6 in number. Apart from that, there are case laws and the latent maxim that has often been asked in the papers that is there. But in this particular lecture series, we are only be confining ourselves to those areas of those subjects of, if I may say, the acts which are relevant for the preparation of CLAT and not the whole act as such. So it is a very comprehensive and efficient video for all those aspirants who are planning to give the examination this year or maybe the years to come, because this particular lecture series will assist you in understanding the basic terminology and the basic concept and the overall underlining concept which is required by the CLAT aspirants to understand, so that they can use those principles to apply in the questions that will be there. And after approaching those questions by using the correct principles, they will be able to answer the questions very correctly. In our previous lecture series, we have started with the Indian Penal Code. Prior to that series, we have already completed Indian Contract Act. In Indian Contract Act, we have discussed the basic principles of how the contract is formed, what exactly is agreements, and how agreements can be made enforceable in the court of law if they follow certain requisites. We have talked about different sections that are important and how an offer, meaning which the proposal, comes to become a contract. What are the important requisites? How we have to make sure that a contract whichsoever has been formed should assist not only our client, but should provide a framework where which nobody should be harmed. So all those essential elements has been discussed in those lecture series. If you feel that you need to get some guidance in regards to Indian Contract Act, and if you're not satisfied or you're not able to understand the basic terminologies, then I would strongly recommend you to go through those videos. It will be very helpful for you. And with this, I would like to tell you that what we have done so far in our another subject, that is the Indian Penal Code. We have started with the criminal law. And criminal law, as I have discussed with you earlier also in our previous videos, that we have confined ourselves to 3 major criminal laws, one being the substantive law, that is the Indian Penal Code, which we are going to discuss today itself. And then the second being the Code of Criminal Procedure, which describes what exactly is the procedure that will be required in whenever there is a dispute or whenever there is a crime that takes place in the society, from the commission of the crime till providing to the justice. What exactly is the procedure that has to be followed? How the FIR will be lodged? What is the provisions for the magistrate to take actions directly? Can a complaint be filed directly to the courts? What is the procedure that the police has to follow? Each and everything, whether a complaint can be taken back or not. What you have to do if the complaint is not being filed? What if the FIR is not being lodged? So all these information is present in the Code of Criminal Procedure. So in the gist, it provides you a detailed framework that what will be the procedure. But if you take it in relation to your CLAT preparation, that you don't have to go to that level. You don't have to study the provisions to that extent and so in that depth. Rather, you are expected to understand only the basic phenomena that will be made applicable. That what is exactly the hierarchy of the courts. If there is a case which relates to murder, to which court that case should be addressed to. How the jurisdiction of the courts are now they are mentioned, they are marked, and how to approach to the correct court. That is the main gist that you need to understand when you talk about the Code of Criminal Procedure. And there are certain other things also that we will be going through when we will be discussing about the Code of Criminal Procedure. Moving forward, then we have the Indian Evidence Act. Indian Evidence Act is perhaps considered to be both substantive as well as procedural, because it provides us with a detailed framework that will be utilized in the court of law, and how the evidences will be presented. What are the things that can be considered as evidence, and what are the things that will not be considered as an evidence? All these things has to be understood through the legislation, that the name of the Indian Evidence Act, that was enacted in the year 1872. Now, coming back to our current lecture series, I have informed you in our previous lecture about certain basic principles about Indian Penal Code. We have discussed about that how exactly a commission of an act will constitute into a crime when somebody has done some unlawful act with the guilty mind. That is, there is an act which is unlawful, that is actus reus, if I talk about the Latin term, and then there is mens rea, which talks about the guilty mind. So whenever there is a mens rea and whenever there is a guilty act, that is actus reus, it will constitute a crime. In order to understand that what exactly a crime means, what are the different forms of crimes, what exactly is the definition of murder, what will you call rape, what will you call defamation, what will you call theft, what will you call cheating, all these things, in order to understand that what exactly are these things and how it has been defined, that whether if I slap somebody, whether it will be considered as hurt, or whether it will be considered as grievous hurt, or whether it will be considered as use of force, or it will be considered as assault or battery. So these things, these general terminologies needs to be addressed and needs to be understood whenever there is any talk or any discussion in regards to the offenses that is there. What exactly will be the punishment of those offenses? All these things has to be understood. And the questions that will be coming upfront in your question papers will obviously be coming from these definitions only, because the definitions of these crimes has been mentioned specifically under the different sections of the Indian Penal Code 1860. The Indian Penal Code 1860 provides us with a varied range of 511 sections, which provides us about the different crimes that will be considered if there is any act which falls within the requisites of these sections, then the person who has done that act can be considered guilty of committing that particular crime. For the clear understanding of the readers, the whole act, which comprises of 511 sections, has been divided into 23 chapters, and within these 23 chapters you find mentions of these 511 sections. The reason for dividing the whole BEAR Act into this particular chapter was to make the readers and everybody who has been the part of India territory and who is practicing law, and whomsoever has been the victim or want to defend his case or been accused of something which is criminal in nature according to the definition that has been given under the Indian Penal Code. So first we need to understand that what exactly are those requisites. And for that, it becomes very necessary to go through the BEAR Act or the legislation, which is the Indian Penal Code. In our previous lecture, we have just briefly understood that how exactly the BEAR Act looks like, and what are the things that we need to study for our preparation for your CLAT examination. As I've already told you that this will be a comprehensive lecture series, so we will not be confining ourselves only to those areas. We will be only confining ourselves to those areas which are important in nature, and not to those areas which might be helpful for you maybe after 10 years, but not as of now. So just because we are very much clear that the approach should be straightforward, we should not study anything which is not relevant. It becomes very essential to stick to only those parts which are perhaps necessary. In our previous lectures, series, rather the previous lecture, if I would say, we have discussed the important sections, and I have told you that what are the provisions or what are the things that you need to study. Apart from the important sections, the most important requisite that a candidate is expected to go through whenever there is any talk about the criminal side of the law, or maybe if I'll say the criminal law, then you need to understand that crime is only known through IPC. I'll give you an example. If there would have been no 302, that is murder, then if you kill somebody, under which section do we have to punish you? Under which section? This would have become a question. So only because section 302 defines murder and majority of the other sections define the different crimes, it becomes very essential for every person to understand what exactly crimes means and what exactly is the definition. But take an example that you might have committed a crime according to you, but you had no intentions of doing it. But the act was committed by you. Then the lawmakers were of the opinion that the person who had but no intentions, as we have already discussed, in order to constitute a crime, the two important requisites are actus reus plus mens rea. So we can see that actus reus is something that will be visible, which can be seen, which can be perceived. And mens rea is something which talks about guilty mind, which actually cannot be perceived but can be observed. So, in order to understand that what are those areas where which it prima facie looks like that it is a crime that has been committed, but since there was no presence of mens rea, or if I may say, it falls within the category of general exceptions, that even if you have murdered somebody, but that murder was done in order to save your life or in order to save some other life, then it will not constitute murder because it is falling within the ambit of a general exceptions. That right to private defense cannot be curtailed, and if somebody kills somebody during the right to private defense, then he will not be punished for the crime that he has committed, because he was actually trying to save his life or somebody's other's life. So in the same way, we in our previous lectures have studied the different exceptions which provides us the safeguard that even if the crime has been committed, it will not be constituted as that particular offense because it is falling within the ambit of these different sections. I have discussed in our previous lecture series, in our previous lecture, Section 76, I have talked about the soldier firing at the mob at the orders of the superior. Conformity with the commands of the law, A has committed no offense. That we have already studied. So in this way, we have studied about the acts of the judge, that whatsoever judges are saying, they are immune to any criminal liability over the same. So if let's take example, V.Y. Chandrachud sentences somebody to death penalty, then it doesn't mean that he has committed murder because he is acting judicially. Then act done by a person pursuant to the judgment or order of the court, when we talk about section 78. So we need to understand, in order to remember section 78, all you need to do is remember hangman. The pen is not working. Let me try again. Yes, hangman. So hangman is that person who is authorized by the court to hang the person when a death penalty has been sentenced to that accused or the guilty person. And when the verdict is passed, it is the hangman who hangs that person until he dies. So if we perceive through our eyes, the act that was done by the hangman constitutes a criminal act, right? But whether there was a guilty intention, whether there were mens rea was present, no. Why? Because he was doing an act that was pursuant to the judgment or the order of the court. So it means that the person was bound by the law to do that particular act because it was the order of the court. So nothing in the according to even IPC can be considered as an offense if it is falling within the ambit of general exceptions. Clear? So general exception has to be understood in a very clear, crisp and precise manner. The reason being, the questions that you will be getting in your CLAT examinations will obviously be coming through these areas in relation to the general crime definitions that has been given under IPC. So for example, there is a definition of murder 302, which talks about that there will be if somebody with the intention of causing grievous hurt or anything, and the person dies because of that act, then the person has committed murder. So this is the rough definition. Obviously, I will be just looking forward and I will explain it to you what exactly the definition of 302 murder according to section 302 of IPC 1860. But what we need to understand is that if at all that murder was committed by virtue of utilizing its rights to private defense, then it would have not considered as murder. So once you have acquainted with the general exceptions, even if after reading one crime, the definition of one crime, be it theft, be it extortion, be it robbery, be it murder, be it attempt to murder, defamation, whatsoever crime is, if they're falling within the ambit of general exceptions, then obviously the person cannot be tried for that offense. And we have discussed till, I suppose, section 85. Just let me clearly check it. Yes, we have to start with section 87. So what does section 87 says? It specifically says that act not intended and not known to be likely to cause death or grievous hurt done by consent. So if you do something by consent, and I have just discussed a latent provision in our previous lecture only, and I will discuss it with you right away also, that is voluntary non-fit injuria. No, voluntary non-fit injuria, which specifically means that if you have given the consent, then at that point of time, even if the murder is being caused or if the death has been caused, then it will not be considered as the murder, or you will not be held liable for grievous hurt. The reason being, you have already got the consent to do that particular act. Let's see what exactly this particular paragraph is saying for you to better understand. And then eventually I'll just explain you the illustration, and then we'll move forward to that what are the general exceptions that we need to understand, because we need to complete the general exception at least by today end of the video, and so that we can focus on the general offenses, the definition of the general offenses, so that we can conclude with our Indian Penal Code and we can move forward to a next subject. So nothing which is not intended to cause death, okay, not intended to cause death or grievous hurt, and which is not known by a doer to be likely to cause death or grievous hurt, is an offense by reason of any harm which it may cause or be attended by the doer to cause to any person above 18 years of age who has given consent, whether express or implied, to suffer that harm. This is the word that we are looking forward for. So this is the word that we are looking forward: who has given consent, whether express or implied. Who has given consent, express or implied. So whenever there is a consent that has been given express and implied, it specifically means that that particular person is accepting that even if there will be any injuries to me, it is me who is voluntarily wish to go those harms, to inflict those harms to me, and nobody should be held liable for the same, to suffer that harm or by reasons of any harm which may be known by the doer to be likely to cause to any such person who has consented to take the risk of that harm. Okay? Who has consented to take the risk of that harm. So here the important requisite is that the person is consenting to the harm that has been committed. Now, one needs to understand that the consent should be for almost the same act for which the person to whom the injury is going to be inflicted has consented for that particular act only. So it cannot be said that the person has given the consent and the person can be held liable for grievous hurt if that particular person is giving the consent for some another act, and the act which has been done is some another, meaning which the crime for which the person to whom the wrong is being inflicted should give his consent for the same act that has been committed against him. You cannot say that, okay, I had given my consent for you to hurt me, but instead you have defamed me. So that is not at all consent, because the consent was given only to do that act which might cause hurt to the person, but should not cause defamation to that person. So that exception will not be contained in that scenario. So the most important portion in this section is that we need to understand that the act and the consent should be for the same manner. You can understand it almost like the agreement of the Indian Contract Act, that both the parties should agree for the things that has been mentioned into the agreement in the same way and in the same sense. So that is why it becomes very important. Let's take the example. A and Z agrees to fence with each other for amusement. Okay. So let's take example. This is amusement park, and in order to fence it, A and Z agreed. Understood? I'm so sorry for the drawing, but let's take this as an example. Yes. So this fencing was either done by A or by Z. Now, this agreement implies that the consent of each other to suffer any harm which in the course of such fencing may be caused without foul play. Here it is important, without foul play. It is not like that if the other person is playing fairly, then it shouldn't be valid. And this exception cannot be taken at that point of time. But if A, while playing fairly, hurts Z, A commits no offense. Okay. And the best example of this particular section is whenever you go to the cricket ground in order to see cricket, and whenever the balls comes to you and you either if you're hurt, at that point of time you cannot go to the BCCI and claim that I was hurt by the ball that comes from the ground, so I need compensation. I want the actions against that particular person, because it has been understood when you purchase the ticket that you have consented that even if the ball hits me, I will. There cannot be an action that can be taken against the person who has done it. Yes, I suppose it is more than understandable. Remember the stadium, in order to retain this particular act. Yes, stadium will help you to retain it. Let's move forward. This I suppose you have already studied. This is an act not intended to cause death, done by the consent in good faith for the person's benefit. Nothing. See, this is a surgeon knowing that. So if you just have to remember this particular section, you just remember a surgeon. Surgeon helps you to remember this thing, that if something is done by consent, in good faith, not in bad faith. Now, what is in good faith, in bad faith? In good faith means that the person never had the intention to harm the other person, and he was abiding by the law, he was doing his duty, and he was honest when when he committed that act. that I have no guilty intentions and I am doing that particular thing honestly. So that is considered as good faith. But if you see the word mentioned as bad faith, it specifically means that the person who has been accused of some crime has done that act in bad faith, knowing that this particular act is going to cause harm. He had the intention of causing the harm, and because of that act of his, the harm has been committed, or the harm has been done. Yes, the best example you can remember is a surgeon. Now, 89th talks about act done in good faith for the benefit of child or insane person by consent of the guardian. Okay. So now if you can see that this you can just see by guardian or by the consent of guardian. It will be much more easier for you to understand that any act which is done in good faith for the benefit of the child or insane person. So benefit of the child or insane person means that either child or the insane person. It shouldn't be like child. It should be child also and it should be insane also. No, not like that. But rather a child means a person who has not attained the age of 18 years. Yes. So child is a person who has not attained the age of 18 years, and insane person is that person who is incapable of taking rational decision. Yes, I suppose this is clear. So nothing which is done in good faith for the benefit of a person under 12 years of age. Okay. Now you see this is 12 for the benefit of a person under 12 years of age or of unsound mind. So here instead of 18 you mention 12. Unsound mind by or by consent, either express or implied. So the consent that has been given by the guardian should be express or implied. It can be both. Of the guardian or other person having lawful charge of the person is an offense by reason of any harm which it may cause or be intended by the doer to cause or known by the doer that to be likely to cause, provided. So now it is saying is that it will never be considered that there is a crime that has happened if the person, the wrongdoer, had the consent of the guardian or by the consent of the guardian, or if at all by the guardian itself, if some act has been done, believing it to be for the betterment of that person without thinking of providing any harm to that person, that particularly shall not be considered as an offense. But there are certain exceptions to this particular exception also. The first is that it cannot be extended to intentional causing death or the attempt to cause death. Okay. So now, why we are saying this? Because in India, by Gyan Kaur case, it was said that passive euthanasia is not allowed. Rather, right to die is also not available. Meaning which, what we are trying to understand here is that the exception shall not extend to the intentional causing of the death. That means the guardian thinking of that it is going to benefit the minor child or unsound mind thought of killing. Let's take example that the child was suffering from acute pain, and there was lots of problems that was going on, health problems that were there, and the boy was actually struggling to live few days of his life, and seeing to that the guardian believed that it's in order to put on rest that pain that the unsound child or the minor child is suffering. So it's better to cause death of that child so that his sufferings would come to an end. But for that also, it is constituted as an offense because you have no right to take somebody's uh, life, even if it is going to benefit the person against whom the action has been taken, means the person who has died. Secondly, that this exception shall not extend to doing anything which the person doing it knows to likely cause death for any purpose other than preventing the death or grievous hurt or cursing or curing of any grievous disease or infirmity. So what does the section means? That it shall not extend to doing anything which the person doing is likely to cause death. The first point is to cause death for any purpose other than the preventing of death or grievous hurt. So in order to prevent death or grievous hurt, if somebody has a minor child in his hand and of unsound mind, and what happens is that there was a grave and sudden danger that was imminent to the guardian. So what he does is that he throws the child into some place, and during that throwing, the person has curtailed lots of injuries, because of which he was hospitalized for a continuous period of maybe 25-30 days. And in general concept, it would have considered to be an offense. But here, if the act which has been done, if it causes hurt only or death only, then it will not be considered as an exception under section 89, because whenever there is a grievous hurt or death, then obviously the person against whom those injuries are being inflicted should be given a right to tackle those problems and injuries. So in the same way, when you talk about the third exception, which talks about voluntary causing of grievous hurt, if there is a voluntary causing of grievous hurt also, then also that is not applicable. But for you guys, I suppose this you don't have to go through all the provisions, because there won't be questions as such from this particular areas, but there will be questions from this. There will be a question where which you will be asked that there is a stadium where which there are lots of students who are sitting, or for the game they have gone, and suddenly a ball came to there was a six that was hit, and the ball came and hit the victim, and the victim wanted to take the matters to the court and want to file for compensation and to take actions, criminal actions against the wrongdoer for hurt, and charge them under section 323 and section 225. Now, because they are falling under this exception, the person will not be able to get his case filed, and they will be the case will be rejected. Okay. Now, section 90 also is talking about the consent that is given under fear or misconception. A consent is not such a consent as is intended by any sections of this code if the consent is given by a person under fear of injury or under a misconception of fact, or if the person doing the act knows or has reasons to believe that the consent was given in consequence of such fear or misconception. Okay, if the person is doing the act has reasons to believe that the consent was given in consequence of such fear or misconception, that even after doing the act, the person feels, and this is very important section, because I'll tell you that majority of the advocates take recourse to this particular section in order to save their clients. The consent is not such a consent as is intended by any section of this act. Okay, so what it specifically means is that the consent which we know as a layman is not the same consent accordingly which has been mentioned under this section, or rather in this code, if the consent is given by a person which is obtained either through fear of hurt or by misconception. So that consent is not considered to be consent. Consent by insane person, if the consent is given by a person who from unsoundness of mind or intoxication is unable to understand the nature and consequence of that to which he gives his consent. because obviously then that consent is not applicable, and under the 12 years of age also, if it is child, it is not applicable. Okay, 91, you don't have to study, right? 91 is not for you. Act done in good faith for the benefit of person without consent. This is something also you need not deal with. Communication made in good faith. This is also an important thing. Section 93, important section. Communication made in good faith. You just first need to understand what it is saying. It is saying that no communication made in good faith is an offense by reason of any harm to the person to whom it is made, if it is made for the benefit of the person. Example is, there was one person who was suffering from cancer. The doctor specifically told him that, see, we will try our level best, but we cannot assure you that you will be able to survive because you have already reached to stage 4 of that particular cancer. And merely the patient heard it, he suffered a heart attack and he died in consequence of that heart attack. So the question was whether the judge or whether the doctor should be held responsible for the death of the person. Then it was argued that by the virtues of section 93, which talks about that communication that has been made in good faith and not in bad faith, cannot be constituted as a crime because it has a protection under section 93 of the Indian Penal Code. Okay, moving forward, act to which a person is compelled by threats. So that is something that we don't need to deal with. And this is a very important section, act causing slight harm, because there has been remarks and observations that in your previous year question papers also, questions are coming from section 95, where which person will be asked that this particular act has been done, whether at all if we can take any actions against the other person or not. So those crimes which are very slight in nature are not punishable under the Indian Penal Code, and that's what section 95 is trying to explain. In the same way, we have right to private defense, section 96, which talks about that nothing is an offense which is done in exercise of the right to private defense. And the 1997 is saying every person has the right subject to restriction contained in section 99 to defend. Now, what does section 99 says? Act where there is no right to private defense which does not reasonably cause the apprehension or death or grievous hurt, if done or attempted to be done by a public servant acting in good faith under the colors of his office, through that act may not be strictly, though that act may not be strictly justified by the law. There is no right of private defense against an act which does not reasonably cause the apprehension of death or grievous hurt if done or attempted to be done by the directions of the public servant acting in good faith under the colors of his office, that the directions may not be strictly justified by law. So the right to private defense is something that you can be curtailed, and the only requisite that you need to remember, and this is very important and you should be able to retain it, that whenever we talk about private defense, the first thing that we need to see is whether there is cause of apprehension of death or grievous hurt, and for more precision I would like to tell you immediate. That it cannot be considered as a right to private defense once there was a call, and on that call somebody started extorting revenue from X person, and then that person just because he was worried, instead of just going and meeting that person, what he did was he planned it was a well planned murder for the person who was actually extorting it, and consequences of that, the person killed that person. And then he started claiming right to private defense, stating that I was under the impression that he will kill me if I will not take any actions as such, and so I initially decided that I will be moving forward and I would be taking that action against the person or against the victim. So that is something that you need to understand, that there is no right of private defense against an act which does not reasonably cause the apprehension of death or grievous hurt. But if there is a reasonable apprehension of death or grievous hurt, then obviously the section of right to private defense is applicable. Okay, understood? Yes. That is more than sufficient for you guys to understand in the general exceptions. When we talk about, let's talk about section. Okay. So when such rights extend to causing any harm other than death. This is not important for you. You need not study. Commencement, continuation of right to prevents until unless that force has not been. The only thing that you need to remember is that the continuation of right to private defense will continue until unless there is a reasonable apprehension of danger that has been removed. So if there is a reasonable apprehension of danger and to that extent the person is defending himself, then the utilization of right to private defense is perhaps correct. But even after the other person has stopped from apprehending the danger and still the victim keeps on beating the other person, then it will not be considered as it cannot be considered as the use of private defense, because what we see here is that majority of the time the person against whom the action has been taken will obviously become more angry and will start beating the other person to another level, which is not recommended, because it is obviously been said that nobody is allowed to take law in their own hand and provide justice. It is the work of the judiciary, and it is some small message for all of you guys that even if you have seen lots of issues and conflicts going on in your society, in your family, it is always suggestible and always a great suggestion from your side that don't take hands in your own hand. Okay, don't take anything in your own hands thinking that okay, I have to manage these things and everything, because that specifically is not the work that we are supposed to do. So it is obviously understood that the person who is going to tackle these scenarios is obviously the judiciary, and they will be tackling it in a better way. Moving forward, let's talk about, we have talked about till here, when we're talking about general exceptions, we have talked about in relations to the body. But then there are again general exceptions in relation to the property also, in relation to private defense. Then when it is so that you can avail the protection of private defense, the first being obviously when they have understood that when no right to private defense is there, and when the right to private defense has to be there is mentioned under section 100. So if there is a assault, first all you need to remember is assault. There is assault. Then grievous hurt, committing rape, gratifying unnatural lust, kidnapping or abduction, wrongful confinement, public authorities के पास they don't have the recourse to the public authorities, and any act of throwing acid. All these 7 points according to section 100 provides you right of private defense. I suppose these things are clear to you now, that what are the grounds over which you can utilize the right to private defense. And the important requisite that you need to remember and always keep in mind is that there should be a reasonable apprehension of danger. Without reasonable apprehension of danger, right to private defense cannot be taken into consideration. In the same way, when we have completed the body part, now we have to see to it that how the right to private defense can be utilized when we talk about property. So if according to section 103 extend to property when if there are chances of robbery is theft. Okay, so in order to make you people acquainted with the robbery, first I will have to explain you what is theft. And when theft accompanied by use of weapons, by two or more people, then it's constitute robbery. Okay. Now, moving forward, the house break by night. Robbery, you have understood that the person is trying to take the valuable items from somebody and they planned, and then basically with the common intention they did that particular act. But when you talk about a house breaking by night, that if somebody breaks into your house, then you have the right to cause the death of the person also. If you see that the person has breaking in to your house. If somebody has done mischief by fire in any vessel, building or tent, then also that person can be held responsible, and we can take the right to private defense of property extending to causing death. So we can even cause the death of that person and still we will not be held liable. So with this, the private defense, the important portion of the private defense has been completed. And with this, I would just request you guys to go through the whole general exceptions once, because after you've understood the general exceptions, we have already discussed in a very thorough manner that what are the things that one has to go through when we talk about the Indian Penal Code. And the majority of the question that you will be getting in your paper will be from these general exceptions only. Once you have understood the provisions, the sections that will be there, and by cross-checking it whether any exception is not falling within the ambit of the paragraph that has been provided, it will be very easier for you to solve those questions, right? So this chapter 4 of your Indian Penal Code, which talks about the general exceptions, has been completed. You are again requested to go through the whole provisions, and if at all you are not able to understand the things in a clearer manner, then you are expected that you will again take recourse to the PDF or the online or the offline book that will be available, or the BERAC that is there, and you'll try to understand that what exactly through illustration, that what exactly this particular section is actually talking about. Moving forward, once after this, we have to also see that what are the other things that we will be studying in our lectures to come. And the things that we are going to move forward is that we will be starting with the important offenses that is often been asked in your papers. And I have told you that if we need not go with chapter 1, the chapter 1 is almost not of use for you. Neither you are supposed to go through chapter 2, because it also about the definition, what is gender, what is number, man, woman, etc. But if you are able to go through this and clearly remember the definitions that has been mentioned, then it will be an extra point for you. The punishments, when we talk about, just I will explain it to you here so that you can even remember for a certain period of time, that the punishments that is being given in India are basically, first is death, the second being is imprisonment, which is divided into two portions, that is one being simple and the other being rigorous. So in rigorous, the person is expected to do manual labor. Then you have life imprisonment also. Then you have fine. Fine is also sort of a punishment that is given whenever there is any criminal act that has been committed. And apart from that, you don't have to go through chapter 3 as such, because it is not relevant for you as of now. Chapter 4, which talks about the general exceptions, that we have already studied. Chapter 5 is abatement. Abatement, I would just like to explain it to you here, that abatement of a thing means that somebody has provided resources or assisted or helped or provided methods to do such act. All these things will be considered to be abatement of a thing. Abatement means to abate a thing, and the person who does that known as abater. Okay, so this, apart from this, you don't have to study what exactly that these definitions are talking about, the sections are talking about, but you should have a clear and crisp idea what exactly abatement mean. When we talk about chapter 5a, which talks about criminal conspiracy, we have to understand what is criminal conspiracy, and then we have to study the definition of it. Then after that, this particular chapter is not important because we are not supposed to study it. Relating to Army, Navy and Air Force obviously is not understandable and not required right now. We will be dealing with unlawful assembly, and then we will be coming to the most important portions of our CLAT preparation in regards to legal reasoning and specifically in regards to Indian Penal Code, the question that will be related to Indian Penal Code, and that specifically starts from chapter 16. So chapter 16 talks about offenses affecting human body. First is murder. First is culpable homicide. Second is being murder. Then you have culpable homicide by causing. So that's the most important thing that you need to study. Then after that, we will be studying about 304A and 304B, which talks about dowry death and causing death by negligence. And then we will be moving forward with abatement of suicide. Then we have attempt to murder, and then we have attempt to commit culpable homicide. So these are some important sections that we'll be going through. Then another sections which talks about causing miscarriage without consent. Although these are not relevant for you, but it is expected from the candidate to at least know the fine that the person has to pay. And what punishment you will get. So that is perhaps not very much important for you, but all you need to remember is that there is a provision for miscarriage also. It starts with section 312 and ends section 318. Then you have hurt, grievous hurt, and all these terminologies and things I will be explaining it to you in a detailed manner so that it becomes crystal clear for you, not only for your CLAT competitive examinations, but for other areas of competitive examinations also, whether be it UGC net or any other examination we are talking about. So, force, assault, criminal force, voyeurism, stalking, kidnapping, abduction. Kidnapping and abduction, I would like to tell you that the CLAT consortium is very obsessed with 359 and 362. So one has to be very vigilant whenever we'll be dealing with these sections, because there will be questions in relation to the kidnapping and abductions also. Then another important point is chapter 17, which will be talking about offenses against property. Here we will be dealing about what is theft, what is extortion, and how a theft is considered to be a robbery, and how extortion is considered to be robbery. So these are the things that we will be dealing with. We will also be talking about dacoity. Then we will obviously be talking about section 403 and 404 and criminal breach of trust. That is not relevant for you. Then we will be talking about cheating. What exactly is cheating? And then we'll move forward and we will be discussing about mischief, section 425. Only section 425 is important along with the punishment that is there. And then we will be talking about criminal trespass. This already we will be studying in tort law, but we are expected to go through these sections also. Then this particular chapter you don't have to study. Yes. So with this, I would like to tell you here is that all these important provisions that we have discussed so far, this is very important for your CLAT examination, and it is recommended that once, for example, if you have completed the lecture today, so you please make it a habit that you have to go through the provisions again and again, and you have to apply those provisions in your question paper. So I would request you again, all of you, to kindly go through the sections that are there, then understand the provisions that will be there in your previous year question papers, because I will be explaining you the principles. After understanding those principles, all you need to do is to apply those principles in your current regime or in your question papers. And once you will be able to apply those principles correctly, you will be able to get the correct answer which is expected from your end. Okay, so that will be it for today. One more small thing that I just wanted to discuss with you guys is that apart from this particularly IPC, the only things that I am telling you, you need not go further and need not study anything else apart from this. The reason is that it is a very wide syllabus. We have to study constitution also, we have to study international law also, we have to study intellectual property rights also. Apart from that, we have to study family law also. So these things combined together, it will be very difficult for any candidate who is a CLAT aspirant to retain this much of knowledge. So it is advisable that once you have understood the principles, there is no need of coming and reading and mugging up all the provisions as such. No, you are not required to mug up the provisions. You are not supposed to mug up the provisions. All you need to do is to remember the principles. For example, now we have studied the general exceptions. We know that if there is any act that has been done by a person who is bound by the law, that he has to perform this particular act in good faith, and because of committing that particular act, there is a crime that has been committed, that since he's been falling within that particular ambit of general exceptions, he will not be punished. Any child who is below the age of 7 shall not be considered as criminal even if he has murdered somebody. How did we come to know about all these things? By understanding and by going through the general provisions of the Indian Penal Code. So taking that thing into consideration, all we expect is that you are not mugging up the things, but rather understanding the principles. After understanding the principles, you open your mind and you see to it that how you have to apply these principles in your question papers. Try to solve mock tests, try to solve previous year question papers, which will obviously assist you in understanding what exactly are the areas which you are still lagging, and then apply the principles again and try to solve those questions so that you can be able to achieve for the desired goal, that is 100%, scoring 100% in your legal reasoning and passing the CLAT examination with flying colors. So I suppose that will be it for today's video. We will be continuing with our lecture series, and we will be moving forward for explanation of the general definitions of the different offenses that are there, and the offenses which obviously are of importance, which might be asked in your CLAT examination. So that will be the things that we will be doing tomorrow. Most probably, we will be able to complete the all the important definitions of the crimes that are there by tomorrow. And after that, we will be summarizing the IPC, along with we will be moving forward with the Code of Criminal Procedure. There are nothing much that we have to study in the Code of Criminal Procedure. Just a small portion is there. And then we will be completing with our Indian Evidence Act. Post completion of our criminal law, we will be switching to the constitutional law. So I would request you all to kindly see through all the videos of this particular series for your better understanding. And with this, I would like to sign off. We will be meeting our next video. Okay, guys. Thank you so much, guys. Bye-bye. Take care.